Our next speaker is my colleague Grant Daly, who is our Principal Complaints Manager. Complaints from everyone, including members of the public, is part of our enforcement powers. We'll talk a little bit more about enforcement later on, but Grant will talk you through our complaints policy and our approach to dealing with complaints. So handing over to Grant.
Thank you, Mike, and thank you all for attending. Good afternoon. My name is Grant Daly, and I'm the Principal Complaints Manager at the OEP. In this segment, I'll be explaining a bit more about the OEP complaint system. I'll be outlining the formalities behind submitting a complaint. I'll be explaining why complaints are important to the OEP and how the complaint system integrates into the OEP's wider functions. I'll also be talking about the complaints that we can consider, as well as the matters that the OEP is not able to assist with. In addition to this, I'll be touching on our commitments to those who submit a complaint to us. As I'm sure that many of you are aware, the OEP has a particular purpose, and our remit for considering complaints is outlined in specific detail within the Environment Act. In very specific terms, we are able to consider complaints providing they relate to an alleged failure to comply with environmental law, and that failure relates to England, a reserved matter, i.e. one that only the UK Parliament of Westminster can legislate for, or if our remit is subsequently confirmed, a matter relating to Northern Ireland. All complaints that are submitted to the OEP must relate to a public authority. And on the flip side of this, we are not able to consider complaints that have been submitted themselves by a public authority. It is not the role of the OEP to mediate in disputes between public authorities. Furthermore, all complaints should have exhausted local resolution before the OEP is able to consider them further. By this, I mean that the relevant public authority should have had an opportunity to consider and respond to the matter before we can take it on board. In addition to this, there is an ordinary expectation outlined within the Act that complaints should be submitted within the specified time limit of either 1 year of the event taking place or 3 months after the end of local resolution, whichever is later. The OEP does have the discretion to waive the time limit, but can only do so in very exceptional circumstances. If a member of the public has concerns that meet the outlined criteria, we'd invite them to consider the information on our website and submit a complaints form. On receipt of this form, we would consider the matter in more detail and would make a decision about how to proceed. So in discussing the OEP's complaint system, it is important to remember that the complaints process is one element of a much wider suite of functions that are designed to facilitate the OEP's objectives. In rationalizing the system, I often find it helpful to use the analogy of a mountain stream, with complaints information flowing downhill to the tributaries that are the OEP's functions and objectives. These tributaries themselves will in turn combine to create the river that is the OEP's principal objective of contributing to environmental protection and improving the natural environment. Given the OEP's objectives, the overriding aim of the complaints process is to provide a forum to enable members of the public to submit information to the OEP about alleged failures to comply with environmental law. As has been mentioned, the OEP is a small organisation with a large remit. And from a very pragmatic perspective, it simply would not be possible for all of us to be able to investigate every complaint that we receive. However, while investigations are an important component of the OEP's toolkit, they are not the only reason why complaints are important. Often overlooked is the value that individual complaints and the accumulation of individual complaints brings us in terms of broadening our intelligence whilst identifying key systemic and thematic issues. By integrating the complaints process into the wider functions and through, to use the analogy of the river, creating free-flowing information channels, we are in an opportune position to facilitate the OEP's ability to be able to see the big picture, thereby furthering the OEP's mission of protecting and improving the environment by holding public authorities to account. It is for this reason why I always emphasize the importance of complaints, even if it's not possible for us to take the matter to further investigation. As has been alluded to, the OEP has a very particular purpose, and our remit to consider complaints is outlined in specific detail within the Environment Act. In broad terms, we can consider matters related to a suspected failure to comply with environmental law, with the Environment Act defining environmental law as any legislative provision, other than the devolved provisions in Scotland or Wales, to the extent that it is mainly concerned with environmental protection. What might be less clear, and what I thought it might be helpful for me to clarify at this point, are the matters that we are unable to assist with. So the most obvious group of matters that we are unable to assist with are those that are described as being excluded matters within the Environment Act. This includes matters related to the armed forces and national security. It includes matters relating to taxation, spending, and the allocation of government resources. It also includes matters relating to the disclosure of or access to information. For various reasons, the legislation specifically prohibits us from considering these matters, and accordingly we are unable to take complaints of this nature further. Given the particular purpose of the OEP, it is essential for the organisation to have substantial expertise and a thorough understanding of environmental law, as well as government policy and ambition. It is also necessary for us to have developed knowledge as to the environmental matters that members of the public bring to our attention. However, whilst the OEP does have this expertise, we are unable to provide legal or other advice to individual complainants through the complaints process, or advocate on their behalf. The OEP's objectives are strategic and balanced, and as such it is essential for us to remain independent, impartial and objective at all times. If we were to provide legal advice or advocate on behalf of complainants, we'd risk the accusation of not being objective, and therefore the possible suggestion that we were not complying with our intended purpose. In a very similar vein, given the strategic aim of the OEP, we are unable to use the complaints process as a means of remedying personal injustice or providing individual redress. Whilst it may happen as we conduct our work, it is not the main aim of the process. I thought it might be helpful to end this segment by explaining a bit more about our commitments to those who submit complaints, as is outlined within our customer charter. While we won't be able to consider every complaint, it is our aim to make the complaints process as accessible and transparent as possible. In view of this, those that complain to us can expect to be treated with courtesy and respect. They can expect to receive transparent service with forthcoming explanation as to our processes and decisions. They can also expect to receive open and fair consideration, as well as to be kept updated on our progress with their complaints. In addition to this, they can expect our full commitment to deal with them impartially and without discrimination and prejudice. I hope this presentation has provided you with some further clarity as to our complaints process. Thank you for taking the time to listen, and I will now pass back to Mike.
Thank you so much, Grant, for that comprehensive view of our complaints handling and our approach to dealing with those complaints.